party will have 15 minutes to which to present their case. The appellant may reserve up to 5 minutes for rebuttal as you go forward. If the appellant wish to reserve that time, please let me know once before you not keep track of the clock or keep your time from passage of time. But we are being visual and being recorded, as you both know, so please try to make that fine recording as much as possible. Also, you know, we have a child here, so if you want to use the child's initials, if you would prefer that, if you do that, would be great. And we have our degrees, we're ready to proceed with that.
Thank you, Your Honor. May it please the court. Neil Agrawal for the appellant, Tanya Mitchell, the mother, and I will reserve 5 minutes for rebuttal. Your Honor, the facts of this case are unfortunately tragic, and they're sad, but they are very clear. You had a very sick child. The agency, Summit County Children's Services, or CSB, filed a complaint alleging neglect and dependency. At the conclusion of the state's case before the magistrate, the mother's attorney specifically said, Your Honor, pursuant to Civil Rule 41, I am asking for a dismissal because I don't believe the state has proven its case. The state argued in opposition, saying we think we have presented enough evidence, and the magistrate agreed with the mother's counsel and dismissed the case in total. The state, as it had a right to do, filed objections with the judge. The judge read the transcripts, read the arguments, and found that the state has proven sufficient evidence for a neglect, or for a dependency, but did not present sufficient evidence for neglect. At that time, mother, through her attorney, which was not me, prematurely filed an appeal prior to the dispositional ruling. I got appointed for the appeal. I filed an immediate motion to dismiss, saying there was no dispositional ruling. While that was going on, very tragically, this little girl passed away. The state then filed a motion to dismiss that first appeal based on mootness, and this court, strangely enough, dismissed it based upon the state's motion for dismissing it for mootness, but did not grant my motion to dismiss weeks earlier that I said we didn't have a final appeal to order. But in any case, it went back to the trial judge, and the mother's attorney said, Your Honor, we want the case dismissed, the child has passed away, and we never got to present a defense at the adjudicatory hearing, so we would like to do that. Judge said, and it's very strange, she said, and this is on page 5 of my brief, regarding mother's claim that she did not get to present a defense, she sought a dismissal prior to presenting any evidence. She had appointed counsel and a right to present her defense, but opted to move for dismissal after the state's case was presented. She cannot now claim that she was prejudiced by her own choice and seeks relief from the court on that basis. So in other words, the trial judge is saying, while you had a right to ask for a dismissal, by the magistrate granting your motion to dismiss, you are taking a risk that I may reverse it, and then you will not get to present any defense at that hearing. Well, I don't understand that argument at all, because if you, right below on page 5, I cite where it says under 41b2, after the plaintiff has presented his case, without waiving the right to offer evidence, you may move for a dismissal. Here, the judge is saying the exact opposite. By moving for a dismissal, you have waived your right to present a defense. That, I think, is in violation of the rule. And then as a matter of due process, my client had a right to present evidence in contra of the state at the adjudicatory hearing to prove there was no finding of neglect or dependency. Now, the state, in its brief, makes a couple of, I think, kind of strange arguments. First, they say 41b2 only applies in the juvenile proceeding unless there's a juvenile rule that would clearly preclude it. And the way the rule is written, the burden is on the state to prove that this rule is totally inapplicable to juvenile proceedings. And then the state goes on to list about 7 to 10 cases where it's been used in juvenile court. They used it in permanent custody, they used it in habeas corpus, they used it in custody matters. So the state is undercutting its own argument, saying, here are a bunch of cases where 41b2 has been used in juvenile cases, but we're not sure it applies. They haven't cited one case in the history of Ohio jurisprudence where 41b2 is inapplicable to juvenile court. They said, in fact, you should consider a 29F motion. But the difference between a 29F is 29F is at the conclusion of the case. The magistrate or the judge may dismiss the case or affirm or do whatever it wants at the conclusion of the case. That is not the situation in this case, especially when the mother's attorney specifically says, pursuant to 41, I'm asking the court to find that the state has failed to present basically a sufficiency of evidence argument at that instance. And then they say, very strangely, well, mother did have an opportunity because when CSB filed its objections to the judge, this is on page 9 of their brief, mother had an opportunity to defend by brief in opposition to CSB's objections. So, I think what they're trying to say is when CSB filed objections to the magistrate dismissal, mom should have listed all the evidence she would have put in, she would have argued, she would have listed the witnesses, what she think they would have said, and that would have been good enough to present her evidence at the adjudicatory hearing, even though nobody cross-examined the witnesses, nobody questioned the witnesses or the evidence. My due process argument on making half of mom, I think they would be arguing, if the judge actually did that we didn't have a chance to argue or contradict or confront any of the mom's evidence. How can they present it in their objections when the purpose of the objections is to review what the magistrate did, not to raise new assignment of errors or new arguments that have never been contested or presented?
So what remedy are you seeking from the court here?
We want the finding of the dependency reversed, because that finding of dependency is solely based on the state's the CSB's presenting their evidence without giving mom an opportunity. What should have happened at the conclusion of the objections is the judge should have said, I find that the magistrate committed reversible error in finding that there was not sufficient evidence of a dependency. I am now remanding it back to the magistrate to consider mom's, behalf of the case in finding there was enough evidence for dependency.
So you want us to remand it for further hearing to
Correct.
determine whether dependency should be, whether mom, allow her to present her defense as to the finding of dependency.
Correct. And then finally, the state says, well, there's no prejudice to the mother in this case, but the whole reason they're fighting for this case on behalf of a dead child is so they can use this finding against the mother in any future case. So they're saying there's no prejudice to mom, but we want this finding so we can use it against mother in the case she has any siblings of this child or future children. Well, we got a dependency once, we want to be able to uphold it. So I don't understand that argument either. Either it's prejudicial to the mother or it's not. If it's not prejudicial, why are we even here? And they shouldn't have fought it. So with that, Your Honor, I'll reserve the balance of my time, unless there's any other questions.
May it please the court, Richard Cassay representing Summit County Children's Services Board in this case. Counsel, towards the end of his argument, said CSB was saying that we want to use this adjudication against the mother in future cases. I don't know where CSB said that. Perhaps counsel can enlighten us on rebuttal where CSB said that they want to use this against the mother in future proceedings. Now,
I'm not sure you said that in your brief, but isn't that the case, that is the reason why this issue isn't, for lack of a better term, moot, that this may be something that if mother would have children in the future, that that dependency finding could be used against her?
well, there's a tenuous possibility that would be true. If you look at the permanent custody statute, 2151-414B1E, a prior adjudication of dependency, abuse, neglect can be used as one of the grounds preceding a finding under the best interest factors, but under that subsection, there have to be at least 3 prior adjudications of dependency, abuse, neglect. I think that covers them all. As far as what maybe this court in Darling was concerned with, a future dependency situation where the baby is basically taken from the hospital, and the juvenile court has the ability to adjudicate that child dependent based in some part on the past practices of a parent. That is going to depend on, I think, the actions of the parent in the hospital. I don't know that a parent who gives every indication of being able to care for a child is going to lose the child. So, to answer your question in a roundabout fashion, there's a tenuous possibility of prejudice. Now, what is the rule that applies here? The counsel for the mother is sure that it's Civil Rule 41B2, and for sure, there are cases in Ohio where the appellate courts have used that rule in juvenile court proceedings. However, in none of them, to my recollection, did the appellate court say, or was presented with the issue, is this in fact the correct rule to use here? I don't think any of those cases say that it is. The case I cited is the Sims case, where the father, at the conclusion of the agency case, moved for a judgment of acquittal. The Court of Appeals said, no, you're not moving for acquittal. What you're really doing is moving under Juvenile Rule 29F1, and that would be the proper rule to use. So I think the proper rule to use here is 29F1, combined with the abundant case law that juvenile court proceedings are special statutory proceedings. This court has held that several times, which leads to the question, is Civil Rule 41B2 clearly inapplicable? And CSB would say that it is, because you have 29F1, which can be used to present the same issue that the mother presented in this particular case. And there's nothing in 29F1 that says if your motion is granted, or if your motion is granted and then later reversed, you get to come back. What the mother is saying here, I think, is that 41B2 somehow reincarnates itself after Judge Teodosio sustained CSB's objection, and now I think the mother wants the adjudication of dependency reversed and sent back for an entirely new adjudication hearing. Either that, or we go back to where the CSB left off, and mother gets to present whatever kind of defense she thinks she has. That's possible. Again, though, if we're looking at specific prejudice in this case, I think Judge Teodosio made it pretty clear that this is a dead child because of mother's neglect and mismanagement of the child's diabetes. So, what exactly is CSB trying to say here, strangely or not? The proper rule is not Civil Rule 41B2. The proper rule is Juvenile Rule 29F1. There are significant differences, and as mother has pitched her entire case on 41B2, she should not get whatever kind of relief she's after, something reversed. Nothing should be reversed. Counsel says it's strange that Judge Teodosio remarked that mother did present a defense. Well, she did present a defense. She made a motion that CSB had not proved its case. That is, in a sense, is a defense, and she chose to do that. So I don't know if there's too much more I need to say here. I think it's pretty clear. Is it 29F1 or is it 41B2? And then what are the rights under those particular rules? under 29F1, I think we're at an end. The child is adjudicated, the child is dead. I admit there is some possibility of prejudice, very tenuous, and really centered on mother's misbehavior in the future. That's the only way this could prejudice her. So if there are no other questions, I'll conclude. Thank you.
May it please the court. Right on page 6 of the state's brief, the top full paragraph, the court was within its rights to adjudicate the dependent child as dependent. The policy behind the holding is to protect existing or afterborn siblings of the deceased child. So the state is arguing that this court's case is in re Darling, where you have a deceased child, the finding of dependency, neglect, or abuse, whatever, should continue upon the death of the child because it can be used in a future finding against the mother. Now here they're saying, and again, remember the state couldn't even present a prima facie case of neglect. That was dismissed by both the magistrate and upheld by the trial judge. We're only dealing with the finding of dependency. Now, in the mother's case, and this is on page 4 of my brief, mother's attorney made an oral motion to dismiss the case under Civil Rule 41B2 under the grounds that the state has failed to prove its case. Page 80 to 82, the court granted mother's motion under 41B2. That was the only ground, and the state is saying we only argued 41B2. That's incorrect. We argued 41B2, and we argued due process. As a matter of right, mom had a right to present a defense. Now, if you read through the state's brief and try to find out how does the state address the mother's due process argument, you will not find it. The word due process is not even mentioned in the state's brief. They in no way argue that mother did have a reasonable opportunity. Then they say, well, when you ask for the dismissal at the end of the state's case, that you present your defense. In other words, the 41B2 that says you are not waiving your right to present a defense, and in fact, you are waiving your right to present a defense if you make a 41B2. And they say that's really a Rule 29, Juvenile Rule 29 motion. But there are significant differences between the two. The purposes of Rule 29 is at the conclusion of the state's case, the magistrate can basically do whatever they want. They can uphold the judge, make a finding, dismiss the finding, take more evidence, whatever. That is not the purpose of 41B2. Then they say it has to be clearly inapplicable. So they have to present evidence and a burden on their behalf to say why is this rule clearly inapplicable. And really, as a matter of logic, what is wrong with asking at the conclusion of the state's case, say, Your Honor, I don't think they presented a prima facie case. We'd ask for a dismissal at this point. Now, the trial judge agreed, at least as far as neglect. They couldn't even get over that burden on a prima facie case. If this court says 41B2 is inapplicable, then we have a right to proceed under due process. Mom should have had a right to present evidence and not in our reply brief on objections to say, well, if we had our evidence, this is what we would show, A, B, C, D. I can't imagine that they would say, that's perfectly fine, the judge is free to consider their prospective evidence to go against a finding of dependency. So in conclusion, I asked for this court to reverse and give mom an opportunity to present a defense to the finding of dependency at an adjudicatory hearing. And if there's no other further questions, I rest on that.